I hope you enjoy my video on the overview of Maryland's 2013 ban on assault weapons. Below are the topics that my presentation will discuss. As you can see, one of the topics is the suitability of the law in other states. Because of the many ongoing assault weapons legal challenges, I've included a summary of several case laws to include those cases that might impact any future U.S. Supreme Court decisions. The primary reason for the Maryland 2013 assault weapons ban was the horrific 2012 mass shooting that occurred at the Sandy Hook Elementary School in Newtown, Connecticut. Other reasons for the Maryland ban on assault weapons was based on evidence given during Maryland's 2013 legislative hearing, where one expert testified that the greater the ammunition capacity of the firearm used in a mass shooting, the more victims were injured or killed by gunfire. A second expert at the hearing, the Baltimore County Police Chief, testified that assault weapons presented a danger to law enforcement. A 2017 Newsweek article stated that shooters use large capacity magazines in half of all mass shootings. In the mass shootings that occurred from January 2009 through July 2015, an assault weapon shot an average of 13 people and killed 8 more individuals compared to other mass shootings that did not involve an assault weapon. Many opponents of an assault weapons ban say that the federal assault weapons ban from 1994 through 2004 made no difference. According to a 2019 New York Times article, the federal assault weapons ban resulted in a 25% decrease in mass shootings and a 40% drop in fatalities. The article states that the first studies of the federal ban's effectiveness were inconclusive due to an overall 14% drop in crime during that decade. In the decade after the ban, there was a 347% increase in fatalities and gun massacres, even as overall violent crime continued downward. Also, the fatalities per shooting incident fell during the decade of the federal ban, whereas from 2014 through 2019, the average number of individuals killed in a mass shooting increased by 81%. Since 2014, assault weapons were used in 11 of 15 mass shootings, and 234 of the 271 people that were killed in the mass shootings were killed by weapons that were prohibited under the federal assault weapons ban. Based on the information presented in the previous slides, it is clear that more deaths will occur in a mass shooting when an assault weapon is used. Groups like the National Shooting Sports Foundation, the Trade Association for the Firearms and Ammunition Industry, and Maryland gun owners who challenged the 2013 Maryland ban on assault weapons in court say that the ban infringes on their Second Amendment rights. After the U.S. Court of Appeals for the Fourth Circuit in 2017 found that military-style assault weapons and large-capacity magazines are not protected under the Second Amendment's right to bear arms, the National Shooting Sports Foundation stated that we strongly disagree with the court's unfortunate mischaracterization of the most popular rifles that have been sold for many years to law-abiding Americans for such perfectly lawful uses as target shooting, personal protection, and hunting. Additionally, after the Fourth Circuit's decision, the Director of Public Affairs for the National Rifle Association's Institute for Legislative Action said that the Maryland ban ignores the Supreme Court's guidance from Heller that the Second Amendment protects arms that are in common use at the time for lawful purposes like self-defense. As stated in the previous slide, several groups believe that the Maryland ban on assault weapons infringes on their U.S. constitutional Second Amendment rights. The Second Amendment to the U.S. Constitution states that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. Based on the many legal challenges with regards to the ban on assault weapons, I will provide an overview of several courts' decisions on Second Amendment rights later in the presentation. Surprisingly, as you can see in the graph, Maryland is just one of 6 states that does not have a state constitutional provision for the right to bear arms. In 1994, Congress passed a federal assault weapons ban restricting the manufacture, transfer, and possession of certain semi-automatic assault weapons. The ban exempted individuals who already owned a semi-automatic assault weapon, as the federal law stated, shall not apply to the possession or transfer of any semi-automatic assault weapon otherwise lawfully possessed under federal law on the date of the enactment of this subsection. The law did have many legal challenges, which I will discuss later in the presentation. The federal ban had a 10-year sunset clause, and because Congress did not renew the law, the federal ban expired in 2004. Congress did not state the specific purpose of the semi-automatic assault weapons ban, but did require a study to investigate and study the effect of the ban for the impact, if any, on the violent and drug trafficking crime. Due to the concern in violent crime, Congress passed the federal weapons assault ban with an interest in saving lives. In the same year that Congress passed the federal assault weapons ban, Maryland banned detachable magazines with a capacity of more than 20 rounds and certain weapons defined as assault pistols. As you will see on the next slide, Maryland reduced the capacity to 10 rounds in 2013 as part of the Maryland Firearms Safety Act of 2013. As stated previously, the Maryland assault weapons ban was in response to the horrific 2012 mass shooting that occurred at the Sandy Hook Elementary School. In January 2013, the Maryland Senate first introduced Bill 281, which was titled the Firearms Safety Act of 2013. The bill had many purposes, one of which stated, for the purpose of prohibiting, with certain exceptions, a person from transporting an assault weapon into the state or possessing, selling, offering to sell, transferring, purchasing, or receiving an assault weapon. The bill banned 45 different types of assault weapons and also banned magazines that held over 10 bullets. The ban included many commonly used handguns that held magazines over 10 rounds. The words commonly used are important because the U.S. Supreme Court in District of Columbia v. Heller, a case that I will discuss later in further detail, stated that weapons in common use are protected. In recognizing that magazines are in common use, the Maryland Attorney General stated in his April 2013 25-page opinion that even if we assume that high-capacity detachable magazines are entitled to protection under the Second Amendment, we nonetheless conclude that a complete ban will survive constitutional scrutiny. That is because we are confident after a reviewing court will find that there is a substantial relationship between the prohibition of high-capacity detachable magazines and the state's objectives of controlling crime and protecting law enforcement officers. After the Maryland Attorney General's April 2013 opinion concluded that the legislation was constitutional and legally defensible, the bill, which was approved by the governor in May 2013, contained many firearm statutes to include Section 4-303, which states that a person may not transport an assault weapon into the state or possess, sell, offer to sell, transfer, purchase, or receive an assault weapon. In addition to Maryland, 6 other states and the District of Columbia have a ban on assault weapons. As you can see in the graph, not all of the states that banned assault weapons required the registration of the assault weapons or prohibited the transfer of assault weapons that were owned prior to the ban. Without a uniform law, like the Uniform Commercial Code, many potential loopholes exist. Due to the many legal challenges that occurred after the 1994 federal assault weapons ban, the lower courts had to determine whether the federal ban passed by Congress violated the Second Amendment. In 1996, the U.S. Court of Appeals for the Third Circuit in United States v. Rebar joined 5 other circuits in holding that Congress had the authority to enact the federal assault weapons ban under the Commerce Clause as a regulation of an activity that substantially affects commerce. Also, in further support of the federal assault weapons ban, the Sixth Circuit Court in 2002, in Olympic Arms v. Buckles, held that the semi-automatic assault weapons ban was a legitimate exercise of congressional authority to regulate a significant threat to public health and safety. Based on the numerous appeals court's decisions, a state would most likely be successful to any legal challenges at the district and circuit court levels with regards to banning assault weapons. The U.S. Supreme Court has yet to decide the issue, but came close in District of Columbia v. Heller. In District of Columbia v. Heller, the U.S. Supreme Court in 2008 held that the district's ban on handgun possession in the home violates the Second Amendment, as does its prohibition against rendering any lawful firearm in the home operable for the purpose of immediate self-defense. Perhaps one of the most important historical decisions with regards to gun rights, the court stated that there seems to us no doubt on the basis of both text and history that the Second Amendment conferred an individual right to keep and bear arms. Of course, the right was not unlimited, just as the First Amendment's right of free speech was not. Thus, we do not read the Second Amendment to protect the right of citizens to carry arms for any sort of confrontation, just as we do not read the First Amendment to protect the right of citizens to speak for any purpose. Additionally, it's important to note that the court stated the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes such as short-barreled shotguns. Based on the possible argument that assault weapons are commonly used, it's important to note that the court stated that the sorts of weapons that are protected are those in common use at the time. The court concluded that the Constitution leaves the District of Columbia a variety of tools for combating that problem, including some measures regulating handguns. I will discuss a few of these tools later in the presentation under suitability of the law. The U.S. Supreme Court decision in McDonald v. City of Chicago was just as important as the District of Columbia v. Heller decision because the court held that the right to keep and bear arms is a fundamental right, but a right that is not absolute. This was a critical decision because when a right is determined to be a fundamental right, a court should apply the strict scrutiny test as the standard of review when a legislature passes a law that infringes upon a fundamental right. When applying the strict scrutiny test, a legislator must have passed a law to further a compelling governmental interest. Based on the evidence that more deaths will occur in a mass shooting when an assault weapon is used, it is evident that a state does have a compelling interest to save lives. Based on a compelling interest to save lives, states can use a similar argument that was used in Roe v. Wade. In that 1973 landmark case, the U.S. Supreme Court held that the right to privacy is not absolute and is subject to some limitations, and that where certain fundamental rights are involved, the court has held that the regulation limiting these rights may be justified only by a compelling state interest. In Roe, the district attorney on behalf of the state of Texas argued that the compelling interest was to save life, which is the same argument used by those who favor banning assault weapons. Based on the similarities in Roe and the Second Amendment, both of which involve fundamental rights that are not absolute, states can ban assault weapons and large capacity magazines due to a compelling state interest to save lives. As stated previously, the U.S. Court of Appeals for the Fourth Circuit in 2017 found that Maryland's ban on military assault weapons and large capacity magazines were not protected under the Second Amendment right to bear arms. Even though in the Maryland case, Colby v. Hogan, where a lower standard of review, intermediate scrutiny was used, I don't believe the level of scrutiny was significant because the Second Amendment has limits and the state could reasonably argue that the legislator passed the law based on a compelling interest to save lives. Based on the dissenting opinion in the Colby v. Hogan case, the most significant issue that the U.S. Supreme Court will perhaps one day decide is whether semi-automatic assault weapons, which are used for self-defense and hunting, are in such common use that they are protected by the Second Amendment. Because the U.S. Supreme Court denied the 2017 petition to hear the Colby v. Hogan case, any potential ban on assault weapons by a state legislature will certainly be as much determined by the impact of the voters, which leads me to my next topic, the suitability of the law in other states. Because a mass shooting could occur anywhere, an assault weapons ban could be suitable in any state. A 2019 Political Morning Consult poll of 1,960 registered voters found that nearly 70% of all voters would support a ban on assault weapons. As you can see on the slide, the support for a ban is much higher among Democrats than Republicans. Therefore, it's much more likely that an assault weapons ban would be more successful in states that are primarily controlled by Democratic legislatures. Based on the District of Columbia v. Heller Court concluding that the Constitution leaves a variety of tools for combating gun violence, states should consider other measures that were mentioned in the Political Morning Consult poll. As you can see on the slide, the poll found that 91% of voters support background checks on all gun sales. 89% of voters want to block gun sales to people who have been reported as dangerous to law enforcement by mental health providers. 84% want to prevent people convicted of violent misdemeanors from purchasing guns. 83% want a 3-day waiting period before taking a gun home, and 72% support banning high-capacity magazines. This concludes my brief. The next few slides provide the references that were used in my presentation. If you have any questions, please send me an email at the address below. Thank you.